On July 26, 2021, disabled plaintiffs went to Show Low Aquatic Center. Upon using the swimming facilities, the 9-month pregnant plaintiff, Ms. Pustelak, was approached by Jane Doe lifeguard and coerced into climbing in and out of the pool to lift a heavy buoy line, so her autistic child, nonverbal, would swim under, not over, the property of City of Show Low. Upon compliance, Ms. Pustelak banged her pregnant belly on the concrete edge of the pool, potentially injuring her unborn son. Joseph noticed Cynthia was then approached again. This time Jane Doe lifeguard was demanding Ms. Pustelak use a water slide with her 90 pounds, 10-year-old autistic child Isis between her legs to afford Isis use of the water slide, since Isis was non-verbal and couldn't communicate with lifeguards, as stated by defense. This was said in front of a warning sign that stated not to use the slide while pregnant. After this, Cynthia, knowing not to use the water slide while pregnant, ignores the obviously dangerous request. At this point, both parents, being physically unable to ride down the slide with a 90 pounds 10-year-old between their legs, continue to watch Isis patiently wait in line with other children, even smaller and younger children, and Isis kept using the water slide until we were then approached by Becca Alsop Seeley, the manager, who plaintiffs then informed Ms. Seeley that they were all disabled and needed reasonable accommodations. After stating she gets that, she goes on to state we as parents aren't doing enough and threatens the disabled plaintiffs with being arrested by the police, whom she is very close friends with, since her father is a city council member, Mike Alsop. The plaintiffs under duress leave the pool without a refund, instead of potentially facing arrest or police brutality. In the following days, plaintiffs filed a complaint with the City of Show Low. However, after 2 weeks or so, we heard nothing back and called to speak to the ADA coordinator, only to find out they didn't have one. This was immediately a red flag, and with a possible injury to an unborn child, we filed a lawsuit at the Navajo Superior Court. Not knowing the City of Show Low and the Navajo County government are closely tied, being members of the Show Low Chamber of Commerce, employees of the city, and even elected officials. For instance, Deputy County Attorney Brand Clark Courts also either are elected council members but also close family members. After filing this lawsuit, we summons the City of Show Low. On August 5, 2022, our baby is born. Upon receipt of the summons, initiated a meeting between the plaintiffs and City of Show Low officials Ed and Jay Brimhall on approximately August 10th or so. This meeting took place. In the meeting, we were ultimately told by Jay Brimhall to call ahead if we were going to ever use the pool again, further isolating the disabled plaintiffs from future events and activities. Upon starting our case over the subject matter, we faced many challenges, including, but not limited to, again, no ADA coordinator, as well as no real grievance procedures for an ADA complaint. There weren't even materials available, brochures, pamphlets in the lobby, or anything to really help disabled to utilize the court facilities, like the non-disabled nowhere to receive auxiliary aids, including recordings of our hearings. This was just the beginning of the egregions the plaintiffs would incur while pursuing action in the Navajo Superior Court. We filed again on other reasonable accommodations request with the clerk of the courts, and this sensitive document was filed in the court documents, instead of given to the non-existent ADA coordinator. Upon beginning with Judge Melinda Hardy and the defendants' attorneys, the Doyle firm started off by using ADA cases from inmates/prisoners, which I have no criminal record, libaciously putting the disabled on the same legal level as criminals without rights. This was never struck down by Melinda Hardy, and even though we turned it videos and photographs of the actual event, she also struck this blatantly obvious evidence down. We decided to mail Gov. Doug Ducey, expecting he would see the obvious malice of the newly appointed Melinda Hardy. This is approximately when we noticed not only did Governor Ducey had appointed Becca Alsop Seeley's longtime friend Joseph Clark to the bench in the same courthouse our civil rights case was being conducted against Becca Seeley and the City of Show Low. After our letter was delivered to Doug Ducey's office on October 19, 2021, a meeting was called between all the judges at the Navajo Superior Court. After Gov. Doug Ducey contacted the courts about our case, however, it was not to uphold our civil rights. I believe it was to in fact devise a plan to shut down our case. This is when our motion for summary judgment, request for disclosure of eyewitnesses from defense and key photographic and video evidence was struck down on October 22, 2021. During all of this, plaintiffs were also in need of affidavits, photocopies, and notary services. We had asked locally and were referred to a business in Show Low named North Star Business Center, owned and operated by Diana North and her City of Show Low Business Development Coordinator husband Steve North. This couple gladly accepted all of our documents and even notarized our sworn affidavits many times. She would give them to the plaintiffs for free and even stay open late or on holidays just to service the plaintiffs. Normally this would be looked at as a kind gesture. However, Ms. North knew after each time we came she could pass along copies and direct information from our court documents to her longtime friend Becca Alsop Seeley. Ms. North also aware our lawsuit was against the city of Show Low, the same city her husband works for. She knew she was obstructing justice and she knew it was tampering, but still passed this information on to the defendants as a good member of the Show Low Chamber of Commerce to another fellow member. Ultimately proceedings continued on and the egregions did as well. Upon denying the plaintiffs the direct evidence and motion for summary judgment, Melinda Hardy, in cahoots with her clerk Vicki Lester, thought it would be funny to then schedule a hearing for the plaintiffs, whom are both legally ordained reverends, on Sunday, December 6, 2021 at 9:30 a.m., intentionally to disrupt our day of worship. After this, the malicious intentional attack on our First Amendment, the clerk rescheduled another hearing. During this hearing, defense attorney agrees to conduct a settlement hearing and asks Ms. Pustelok how she spells her name, even pronounces it several times correctly. However, this scheduled settlement hearing was never given to the disabled plaintiffs in a timely manner, nor was ever a physical order ever received in the mail, as needed by the disabled plaintiffs. It was in the next hearing that we realized we are being delayed intentionally to wear down the statute of limitations, and then the discrimination went too far. In the hearing scheduled on March 25, 2022, Melinda Hardy, speaking to now defense attorney Brandon Millian, and when speaking to the plaintiffs, decides to call Ms. Pustelok a Nazi-derived racial derogatory slur. Instead of referring to Ms. Pustelok as Ms. Pustelok, she repeatedly, even after being corrected, insisted on referring to her as Ms. Polak. This is filed on May 1st for a reason. It is May Day. May Day is historically known as a call or a cry for help, and there could not be a better reason than the ultimate deprivations and conspiracy of depriving possibly millions of Americans in Arizona their afforded civil rights.